Item number 1 and 2.
Short passover, Mr. Banerjee. Short passover.
Item number 3.
Who's in item number 3?
I'm paying for an adjournment, my lord.
Yes.
I'm paying for an adjournment, my lord. I'm for the appellant. Can you take it up on 26th if it's convenient to your lordship?
Ready for hearing?
Yes, it's ready for you.
Senior counsel is unavailable, my lord.
26 Bay.
Yes, my lord.
All right. By consent of learned counsel for the parties, this appeal is adjourned till 26 May.
Much obliged.
Number 4.
These appeals.
My lord, in number 4, lordship has given me time to file a short affidavit. We are unable to file it. Lordship give me 2 weeks time to file a short response to the
Affidavit for what purpose?
My lord. In the last occasion, the state has given a report, submitted report.
A detailed
Persons
report
to
has been
that.
submitted on behalf of the state, your lordship, and my friend here had asked for time to peruse it and to file a reply to that.
My lord, may kindly see order dated 8/6/2025.
855.
85. Where lordship has passed some detailed order.
I was supposed to file by 15th. Yeah. Today we are 25. I know, good for us, we get more time. He's asking for time, we can't do anything.
The order was passed on 8th May.
My lord, lordship allow us to file on or before 15 May. My lord. We are unable to file the response, my lord. So your lordship give me 2 weeks time.
No, but you are not kind of a superintendent over the government
My lord,
to
that is
assess
true.
the report and all that. We will accept the report. And if you are aggrieved, you take out a further application.
But the report has been filed.
Since you have not been able to take any exception to the report, it shows that they have taken proper action.
But if lordship allow me, I can point out also. The report has been given, my lord. That's true. But I was condemned.
We will give you leave to take out another application if you think that this this action plan of the government is not implemented or is failing. You take out another application.
But we have the submissions. Therefore, my lord, the report is filed time and again. Therefore, we want to bring to my lord's notice that on the ground.
No,
nothing is-
you ought to have or must or by now you should have. You can't keep the government in suspension, in suspended animation.
No, my lord. We are, in fact, it's a PIR, we are supporting the government also too. It's a public interest.
Nothing to say. They have taken. If there is further problem, they can pick another application.
And then decide taking. What do you want is responsibility?
If he wanted, he could have done it. When he did. Please take them.
Oh, yeah, supposed to
This public interest litigation involves pencil underlined portion, page 2 of the order dated 8/5/2025. Paragraph by our order dated 8th May 2025.
This was the direction. Wants to peruse the report and file an affidavit.
We had taken on record a report by the government showing action in terms of our earlier order. Full stop. The petitioner was given an opportunity to file a response to the said report by an affidavit by 15th May. Paragraph. Today time is sought on behalf of the petitioner to file this affidavit. Paragraph. We only observe that if the petitioner had any grievance with regard to any policy or plan or implementation of the plan by the government, the response ought to have come by today. Full stop. The affidavit not having been filed shows that the petitioner has got nothing much to say with regard to the action taken. Full stop. However, as a last chance, we grant the petitioner an opportunity of bringing to the notice of this court any lacuna in this report filed by the government by extending the time to file the affidavit till June 2nd. List is public interest litigation once again on 12th June.
You do, right?
Second call, item number 1 and 2.
Yes, Mr. Rani.
But before dealing with the various questions raised by Mr. Shah and Mr. Paul, I want to give a slight overview of the matter without referring to the papers, and why, in my very respectful submission, even the exercise of going into all these questions raised by my learned friends should not be undertaken by the writ court at all. I will, of course, deal with all their questions. But first, let us understand, my lord, what exactly has happened here. And I make it clear, I am proceeding on the basis of one warehouse only. I'll come to Mr. Paul's argument right at the end that you had a second warehouse. There's another writ on that. I'll take that separately. But let us take the writ as it originally framed and as I am dealing with it. One warehouse, which according to my learned friends, gives monopoly power. Now, the question your lordships would have to consider, very important. Your lordship has seen so many judgments cited by Mr. Shah on how, according to him, in various cases the court has interfered because someone's right to business has been taken away. I'll show those judgments later. The question is, before your lordship gets into these fine academic exercises, is a private monopoly maintainable in law? Is it the state only which can have a public monopoly? Is the pricing structure distorting the market? All these things will only come if first and foremost, as has been demonstrated in all those other cases, I'll show a legal injury has been suffered. So today we are not in a law lecture discussing whether academically a particular policy has caused such legal injury to him as would invite the intention of this court. Lordship sees the point. Of course, I will argue even if he has suffered some loss, as he has himself conceded while in passing, simply by suffering a financial loss, the court doesn't interfere unless there's a policy challenge or a legal challenge. But that I'll come to later. First and foremost, before your lordship gets into the matter, let's understand what is his main grievance. Commercial grievance. Your lordship has heard repeated endlessly that, listen, the central bonded warehouse is a creation of the state with no purpose whatsoever. It has no value. It serves no revenue purpose. It serves no regulatory purpose. It is just done there for the sake of it on the whims and fancies of the state. And the net result is that I, the petitioner, are having to pay an extra commission which is affecting my bottom line. This is a sum and substance, the major argument. There are other arguments also.
And Mr. Banerjee, just to remind you, to promote an organization which was established or founded just 1 month before the notification.
Yes, very well, my lord. That in itself will not affect the policy, my lord. My learned friend, that would have been an excellent argument had my learned friend been a tenderer and tried to have the tender cancelled on that basis. Today, he was not the tenderer who tried to have the tender cancelled. Kindly appreciate, this cannot lie in the mouth of the supplier. This can lie in the mouth of a competitor for the tender who can complain the tender was bad and I should have been allotted the tender. Now the tender is final. He was not a tenderer. He has never pretended to be a tenderer. So that really is of no relevance now. Could have been a case of somebody who was affected by the tender. He has to show how he was affected. Now, if he can show that there is favoritism and all that, I'll come to that. I'll come to that point. Now, first and foremost, my lord, kindly sees, my learned friend says, there were one commission has now to take care of two commissions. And as a result, as a supplier, he is having to pay bonded warehouse also, CBW also. Therefore, his cost has gone up for no rhyme or reason. Argument number one. Major argument, commercial loss. This is how he's actually affected. All the other things, my lord, are all notional. Even this is notional, but all the other things are notional. There's discrimination. Somebody may be favored. Supplier may be favored. Bonded warehouse may be favored. I'll come to all that. But his main initial and main argument was, why is this thing being imposed upon me for no rhyme or reason and putting up my cost? Lordship appreciates. Now, for that, as has been done in all those cases which my learned friend has cited, including the Chhattisgarh one and the Uttarakhand one, first you have to show the court that you have suffered a loss. Kindly appreciate. By saying that my commission has gone up, doesn't prove the case. I have filed an affidavit. Kindly appreciate, I'm not showing it today. I'll come to this in detail. I'm giving your lordship an overview. I have filed an affidavit saying that his commission is between 1/2 to 0 to -1%. Unrebutted affidavit. Reality is this. Now, if a person is paying 1-2% commission, and what is his answer? Very interesting. Your Lordship will appreciate this matter has been going on now for 4 years. 4 years the CBW has been functioning, 2001 to 2021 till today. My learned friend says, I have not, the commission which was to be given to CBW at 25% and all that, we have understood that since the matter is pending, therefore commission will not be charged, my lord. This was the argument. Ridiculous, my lord. A commercial organization will not function for 4 years when there is no stay on any commission. Today the CBW could have charged a commission of 30%, according to my learned friend. So, first point I'm making is this. Can we see the market realities? This is not some small businessman who's being driven out of business by the government. We are talking about one of the world's largest liquor combines. Pernod Ricard and this group, the brands which make up this group, they are, we have checked up, we put some figures, of approximately 40% plus of India's liquor market and probably 50 to 60% of Meghalaya's liquor market. So this is a dominant and very powerful force. They will negotiate with the bonded warehouse as to what the rates are agreeable to both of them, and they will decide. And in their wisdom, kindly appreciate, they have decided that the commission will be 1% or 0. What's roughly 1 to 0 minus 1, between -1 and 1 to 2. I've got the additional affidavit. Lordship will take it from me. No response, no rebuttal. Cannot be because it's on record. We have the records. So now, when I ask myself the question, is your Lordship going to decide all these fine questions for a person, a business, which has not suffered any loss? Where is the loss? Your Lordship will appreciate. Let's stick to this commission point first. He has to, Mr. Shah's client has to show at the very instance, at the very beginning, that this was, my lords, the commission which I was having to pay prior to central bonded warehouse. This is the commission I'm now having to pay. See how much I'm being hit. Now I have to pay 10% more. My lord, is that not, I ask myself, the first question before my lord? He is paying nothing extra. He has negotiated because of his 50 to 60% negotiating power, dominant power. He has managed to negotiate with himself, with the CBW, a paltry commission of 1%. And bonded warehouse is protected because the government has given them 8%. So what Mr. Paul's client's injury is, of course, I'll come to later, 0 injury. But forget about him for the time being. So far as Mr. Shah's client is concerned, 1% to 0% commission. That's the affidavit. No rebuttal. Now, first and foremost, is your Lordship, I ask myself the question, going to decide all these sophisticated constitutional questions of private and public monopoly, of discrimination, this, that, on the basis of a person who has not suffered any financial loss?
Government is not giving him any commission.
No.
It's given only Mr.
It is the supplier who pays CBW. It is the supplier who pays the bonded warehouse. The supplier is paying the bonded warehouse 8%, fixed. Possibly the bonded warehouse is getting more or less, we do not know. Bonded warehouse has not come out with any figures. But it was incumbent upon the petitioners, kindly appreciate, this cannot be overemphasized. Petitioners had to show to my lords that before the central bonded warehouse, this was the commission I was charging, I was getting charged by the bonded warehouse. The commission amount was, say, 10%. Now, because of the bonded warehouse, I have to pay them 10% plus another 10% here. Something like this has to be shown to my lords. Otherwise, where is the loss? Only saying in theory, because an intermediate body has come, therefore I've had to pay extra. But have you paid extra? Where is that extra? You have negotiated so that extra has disappeared. That's my contention. I have said so on affidavit, I've given the figures. So, until and unless Mr. Shah's client could demonstrate to my lords that I have suffered some financial injury, where is the question of basing a constitutional challenge on the basis of this extra commission? First question, no answer. To that affidavit we have filed, giving the percentages of commission, there is no answer. Answer is, we are holding our hands because the court is... Now, my lord, if they can hold their hands for 4 years because the matter is pending, then with respect, it's of course unbelievable, but with respect, then there is no such great legal injury for the writ court to interfere in this policy. It's a serious matter to interfere in a policy by the writ court. We are not suffering anything. This is question number one. Kindly examine this very carefully, because the concept is, unless and until a petitioner suffers legal injury, kindly do not go by sympathy that notionally they have to pay something more. Have they paid something more? This court has to see whether they have in fact paid something more. Have they suffered any financial loss? In other judgments I'll come to, they suffered financial loss, but still the court upheld the policy. But there at least they could show the revenue had dropped. Here they have shown nothing. They have not shown the revenue has dropped. They have not shown the commission has gone up. They have not shown their cost has gone up. Oh, they just come to the court and saying, well, you know, now there's an extra body, we'll have to pay something more. With respect, not good enough. And particularly not good enough for an entity which controls 60% or 50 to 60% of the state's liquor market. They have sufficient negotiating power. I'm not saying that they will do this, but if they should choose to pull out, the state of Meghalaya the liquor market will collapse. They are a very powerful force, 60% of the market. So number one, kindly consider whether that legal injury has been suffered by them or not. Because that was Mr. Shah's first point. But he was also fair enough to say that I have a policy challenge, and if I cannot sustain the policy challenge simply because I have to pay more, may not be good enough to strike down the policy. And that was a fair statement, because that is the law. The law is not that if my margin of profit goes down by 1 or 2%, then the policy goes. I'll show your lordship the judgments. Some indirect impact on your balance sheet will not cause the policy to go bad. Well settled. But even that they have not shown. So question one goes to the root of the matter. And if your lordship is with me on question one, that they have not shown any legal injury at all, financial injury that is, then why, I ask myself, would your lordship get into these questions of, is the policy reasonable? Is the policy unreasonable? Is the policy in derogation of section 19 of the Act? These are academic questions. Wait for a person who comes who has suffered loss, then decide it. First principle of the court is, if you decide a matter, you decide it because there is an interest which has to be protected. It's not an academic exercise. One day the commission may go up, 2 years later, so the policy is bad, will not do. Is it affecting you today? Has it affected you in the last 4 years? So why are the figures not there? When we give the affidavit to your lordship, just give me that. Lordship, can give a moment.
May I only request Mr. Banerjee to give us the date of the affidavit he is referring to?
Oh, yes. I'll do that. It's 7th of February 2025, the additional affidavit. 7th February 2025. Kindly gives me a moment. Where is that, brother? Commission chart. Commission chart. Yes. Your lordship will get that at page 9 of this affidavit of 7th of February 2025. These are all the brands of my learned friends' clients. Kindly comes to annexure A1, because I want to make good on this point at least today. Lordship is not, I think, feeling very well today. There's some difficulty.
Burning in the eyes.
Then your lordship need not read to
No.
refer to the paper. I can.
Affidavit.
7th February
No, Mr.
2025.
Banerjee, if we look at it in this way,
Yeah.
say the price, Mr. Shah, you also listen,
Yes.
comprises of cost of manufacture, say, a very layman's point of view.
Yes.
All right. Let us cost of manufacture plus, let us take the commission as K,
A.
erstwhile, before
Erstwhile.
the notification to be
Right.
paid to the CP warehouse. All right. Then profit, taxes, other charges, etc. All this comprises the price.
My lord.
Now, say this component is K, this commission.
My lord.
Now, if this commission has to be paid to two persons,
Yes.
say it becomes K1 and K2. Now, if the price remains constant, let us look at it mathematically.
Yes. I'll answer your lordship mathematically also.
If the price remains constant, then the profit has to come down.
Correct. May I answer?
All right. Now, if this commission, say K1 and K2, is so negotiated
Yes.
that K1 and K2 remains K1, it's not greater than K1, then there is no loss of business, nothing.
Absolutely right. My lord, I couldn't have put it better. I'm very grateful. Only one thing I'll add. One thing just to be.
Now, according to you, now, if another body is created, this central, then the presumption is that they would also have to be paid commission.
Yes. No doubt about it.
With K1 and K2.
Correct.
Now, it is for one who alleges to show that such was the negotiation that this K factor remains constant.
May I answer, my lord? Number one.
Because it is not just loss. Diminution in profit would also
Yes.
affect
Loss
it.
means diminution in profit, my lord. Naturally, the margin, as my learned friend correctly points out, if the cost to the two warehouses exceeds what he had to pay earlier, then it has to come out of his profit. Because I tell your lordship why, and he had also indicated
Loss
that,
is a minus factor, but
no,
diminution,
diminution in profit.
Yes.
Loss.
Instead of 100 crores profit being shown in the balance sheet,
Right.
they would show 70
Right,
because of this.
right.
That would also be a loss of business.
Correct. Now, may I answer? Yes. Number one, it is, the reality is, and that's there in the notification, and my learned friend is also referred in passing, the policy in Meghalaya is, there is a cap on the price, which is the price of the neighboring state of Assam. So the price is fixed. Kindly note, the price is fixed by the excise department. I'll show your lordship on the next occasion. It is actually fixed ex bond by the excise department right at the very beginning. When they register their brand, the price is fixed. So let's say the price fixed is, say for a brand, 500 rupees for old mug, fixed. So everything has to work backwards from the 500 rupees. Right. So no, I say this in passing because an argument was made that if I retain my profit and the price goes up, then the customer will suffer. The customer will not suffer because the customer's price is fixed. Irrespective of commission of my learned friend, the customer's price is fixed. So it can only relate backwards. But yes, it can eat into his profit if there is commission goes up. So we start with K1 and K2. Right. Now may I proceed? With respect, you are the one who is alleging the loss. It is not for me to show that you have not made a loss. It is for you to show to the court that you have made a loss. I have discharged the evidential burden, if one can use that expression, by reason of this chart, where I'm showing 0 and 1%. Kindly see the chart.
It is not there.
22nd Feb 2024.
Give him a copy.
Miscellaneous case, probably that is why.
MC 13 of 25, Your Lordship.
MC 13 of 25.
Kindly come to the first annexure. If I had any burden, I did not have any burden to discharge according to me, but still I have discharged that burden. Kindly come to the last annexure A1, my lord has.
Yes.
Kindly come to the second last column. These are all the brands of the petitioner. Kindly comes to second last column. Kindly sees the margin earned. Kindly goes through the pages. 000 minus 0.6, 00000 minus 1.20. Kindly sees the. It's important your lordship goes through this before your lordship starts thinking about what losses and diminution in profit. Kindly sees what is the reality. The highest I've seen is 2.16 at page 13. Possibly. I may be wrong. Most of it is 0. Occasionally it rises to 2. And one occasion it is 8 and 7, 2 or 3 occasions. Otherwise they are all in a very much lower category. Certainly no one near 25%. Eight, 5, 3, etc., etc. 0.
Margin earned. That is margin earned.
I'm sorry, my lord?
Percent.
Yes. Margin earned by central bearer, the percent. That is the margin which my learned friend is referring to, which is having to be paid by the supplier. There's no issue on this, my lord. This is unrebutted.
I believe this is not an affidavit. This is just a chart that Mr. Banerjee is handing over.
No. It is affirmed. It's affirmed. Let's not get into this. You want me to, if my learned friend has any issue, file an additional affidavit for me. This is part of my petition. And this is verified by the excise authorities.
Annexed to your affidavit.
Yes. If my learned friend wants to dispute it, is most welcome. Let him file an affidavit disputing it. But the point is, today he has conceded that the margin is not being levied because of the pendency of this matter. Please understand what he has said. He is not saying this is wrong. Now, I have already indicated, good or bad, according to the department, the margins are this. Now, K1 plus K2 is, let us say the original margin was A. I'm using your lordship's terminology. K1 plus K2 has to be greater than or equal to A. K1 plus K2.
You are the master, Mr. Banerjee.
No, I think your lordship's college in Xavier's, I had the privilege to be under Father Goro in mathematics honors, so
that is
it's your college. So at least this much, this of course school inequality. K1 plus K2 has to be greater than A.
You did your graduation in mathematics honors.
My lord, whatever, I'm sure Mr. Shah is equally competent on this as your lordship is. But
you and perhaps Sudipta Sarkar.
Yes.
Also.
I'm in a good company, my lord. I think Mr. Bhaskar Gupta also did it, maybe, possibly. That's on a long time back.
And Justice Ajaynath Rai in physics, perhaps. Well,
that's right, man. So, K1 plus K2 is greater than or equal...
All first class.
It's history, my lord. It's history.
That is our knowledge.
It's history, my lord. Anyway, my lord. K1 plus K2 has to be greater than A, then there is a change of situation by which Mr. Shah's client is aggrieved. Now, K1 plus K2 greater than A is ideally to be shown by Mr. Shah, not by me. And my contention and my submission before my lord is, legal injury, financial loss has to be shown by him, by the petitioner, before your lordship entertains the policy challenges. Supposing the policy challenges are very good, and your lordship finds that he has no loss, he has not proved loss. Would your lordship ask me, go into these policy challenges? Your lordship would not, because the court always decides only when it is required to. That's the first principle. If your lordship is not required to, then there's extensive discussions on private monopoly, public monopoly. We'll go into all this, my lord. They're very nice constitutional questions. Section 19, does it have expresso unius, statutory interpretation? Excellent. But first, you have to show 2-3 things. First, is there a loss at all? Second, and this is very important, merely a loss of profit is not a ground for policy challenge under Article 14. Your lordship may take it from me, I'll make good on the authorities. Just because my learned friend, in fact, passing, had also considered that position of law. Merely because you lose money, if the policy is otherwise good, then that cannot be a reason to strike it down. What is possible for my learned friend to argue on policy, provided he crosses the boundary of financial loss, is that the policy is unreasonable, which Mr. Paul has also said. But that is only, my contention is, that is only after my learned friend satisfies the court that there is a financial injury, a legal injury. Today, it's all very well saying this is just a petition, but I have put forward facts and figures. This is the Excise Department of the state. If you say it's wrong, well and good. You show 25%. All that he has is very simple. It's his chart, his figures are with him. He has to simply show before 2021 this notification, my bonded warehouses, my commission was so and so, so and so, so and so. Now my commission is K1 plus this, so I have to pay more. Simple thing to show. My contention is he cannot show it because it is not true. He is not paying more. Whatever he was paying to that single bonded warehouse, now the total is not more than that. Your Lordship draws the adverse inference. He has not discharged his onus of showing the loss. I have discharged an onus, evidential onus of showing his margins are fairly low. It's not within my partly within my knowledge, but fully within his knowledge. So if your Lordship is not satisfied on this preliminary question of financial loss, then where do the policy challenges and other things happen? Your Lordship only intervenes for a person who has suffered injury. Second, legal injury cannot be simple diminution of profit. That's the second point. I'm just giving the outlines today, my lord. Simple diminution of profit or an ancillary loss cannot be a ground for striking down of a policy. I tell your Lordship where the court has entertained challenges. Lordship is rising, or?
So after 5 minutes.
After 5 minutes. Well, then your Lordship.
No, you please proceed.
All right, very well. So, where the court has intervened in matters of policy, I tell your Lordship, two areas. In the area of liquor, which my learned friends has given a fair number of judgments, which definitely, I must compliment him, cover the field on all aspects of liquor policy. So, one area where the court can interfere is, I'm going beyond liquor policy, I'm going on general grounds, is if you completely shut down somebody's business. That is interference with business. For example, suppose, take an example, that Mr. Paul's clients and all bonded warehouses in the state was substituted by one warehouse. Then he would be driven out of business. And his legal injury would be clear. And he would have every right to say, this monopoly should be not be granted because it is not, whether your Lordship would sustain the challenge or not is another matter on policy, right or wrong. But he would have had the locus to challenge because his business is shut. Lordship appreciates. In the cases which Mr. Shah has cited, I'll cite them. All of them, business was shut. Tenduli's business was shut. My learned friend's business is not shut. My learned friend's business is going down by 2% profit, if at all. So the question is, on a 2% profit or 3% profit loss, diminution, which also has not been demonstrated, does it give him the locus to challenge the policy at all? I submit only if his business was drastically affected and directly affected would the question of challenge be entertained by this court. Want to cite? Lordship, may I kindly give?
Choose another date.
Very well, another date. My Lord, your Lordship, I am unfortunately have told Mr. Shah, I know he's not very happy about it.
Yes,
I am not there for the vacation so Lordship kindly keeps it on 10th and 11th of July. My Lord, I'm only coming back on the 8th of July.
I was just wondering, my Lord, if the respondent number 3 can, my Lord, in the meantime continue, because, my Lord, your Lordship has been hearing this.
I have no difficulty with the respondent number 3 making whatever he has to say. I have no problem.
I can.
This bench will not be available before 10th June. So there is
I
no
see.
more.
No,
So,
after 10th
so far I'm
June-
concerned, my lord, 10th and 11th of July, your lordship kindly kiss.
No, but if in between 10th June and 10th July, I was just wondering if the respondent number 3 can make progress because your
That is
lordship
for
has
him.
got-
I will not stand in the way.
Mr. Shah, this matter is going on for 4 years.
4 years,
Why
so yes.
deprive Mr. Banerjee?
Well, I have said
But then,
what I-
you are back on 11th July.
I'm back on the 8th, 10th and 11th. I'll argue, my lord, at least 10th.
So let it be continuously from that.
And 14th, I'm in some difficulty. I can continue again from 15th.
And no, continuously till it is finished.
Well, only 14th, your lordship, excuse me, one day.
Except 14th.
Yes, very well, no problem.
Yeah.
And your lordship, I
After
said
Mr.
day to day continuous. Then I'll make those arrangements. 7, 8, 9 days
Yes,
continuous. Very well.
Well, if Mr. Banerjee can indicate how long he'll take, then we can also take
I will
arrangements
not
to-
take longer than the 9 days which your team has taken. That's a guarantee. I've counted 9 days. So I will take not more than 9 days. Maybe less.
Mr. Banerjee tried to finish it.
I will try, but that's since
3 or 4 days. 3 days.
no. I cannot do it in 3 days. My lord, they have argued for 9 days. You kindly seize the list. My lord, the matter has been going on for 4 years. I have a equal right to equal time. But
We have not argued
sorry.
before your lordship's bench for 9 days. That I can assure your lordship. Before your
I'm
lordship's
sorry?
bench, I think we've argued for 3 days.
9 days, I've got the dates. But,
Not before this bench. Not before this bench.
Yes, before this bench. 9 days. Please give the dates. Before this, I've been appearing only for this bench. 9 days.
14th is a holiday here.
I'm in difficult on 14th.
14th is a holiday in this court.
Oh, I see.
Marked red.
I don't mind. Your lordship keeps it 15, 16, 17th. I have no difficulty.
17th is also a holiday.
Very well. 15th and 16th?
No, between 2 holidays,
Then I'm at your lordship. Your lordship gives me all the days. I'll block them off for this and then I'll take dates
21st,
now.
22nd, 23rd.
21st, 22nd. Very well. Very well. Very well. Right. I will be as brief as possible. Your lordship gives me 1.5 hours each day. I should be able to make progress. But I'll need at least 1.5 hours each day.
All right.
No. Tomorrow and day
Did
after.
You have not informed all the parties.
No, my lord, we have been informed. There is no difficulty.
I've been informed. Mr. Shah has been informed.
Whom are you appearing for? You have not been informed?
The cause list reflects it.
I asked the registry of this court to inform each and every lawyer. That is,
Anyway, we have to start after my learned senior friend.
you have not informed everybody.
Mr. Shah is leaving soon for better parts of the world, I'm sure.
I'm following Mr. Banerjee wherever he goes.
Mr. D.K. Banerjee, Learned Senior Advocate, commences his argument on behalf of the state, but does not conclude the same. Paragraph. Considering the summer vacation in other high courts to which learned counsel appearing in this matter are attached, and the convenience of the court, these appeals are fixed for further hearing on 21st, 22nd and 23rd July, marked at 12 noon.
My lord, I just make it clear. I'm coming on the 10th anyway. I can also do it on 10th and 11th, but that's for your lordship. But that's entirely for my lords.
No, 10th and 11th is perfectly fine, if it is fine with Mr. Shah.
Yes, my lord. 10th and
10th and 11th July.
As Mr. Shah would like some progress in the matter.
10th and 11th July.
Great.
And also 21st, 22nd, 23rd.
No, then
Yes, my lordship said your lordship
then it
will-
becomes like an arbitration.
No, I'm just saying, I tell you, Lordship, if your Lordship is fixing on 21st, 22nd, 23rd also, then I have to keep those dates free for other matters. So, your Lordship kindly indicate.
You see, we are free on all the days. You block those dates and tell us on 11.
Very well. I'm obliged.
Grateful.
And if there is no other kind of supervening impossibility, we shall take it up.
Yes. Well, on the 10th, my Lord, your Lordship.
We are static here. You are everywhere. All right. And mark it, this also 12 noon.
Obliged.